begin by thanking Frank Askin, who is the founder of the First Monday program, and for the Frank and Marilyn Askin Endowed Fund for Clinical Legal Education, which provided us with funds to put this program on this year. Every year, the Knoyce Davis Fellows put on a program discussing a major case that's coming up in the upcoming Supreme Court term. Usually it's not on a Monday. But this year, there was a lot of anxiety in the air, especially since the November election last year. Because we believe that it is our job and our responsibility as public interest lawyers, as people who are interested in human and constitutional rights, to hold the government responsible. We felt that there was such a sense of urgency that we should discuss 3 cases, which is why this year we have a panel discussing IRAP v. Trump, Los Angeles versus Mendez, and Sessions v. Dimaya. These cases respectively deal with the controversial travel ban passed by an executive order by President Trump, which is now on the 3rd part, police brutality, and immigrant rights. I'm now going to turn it over to Omar to introduce some of our speakers.
Hello, everyone. On January 27th, 2017, myself and many other Muslims here and abroad looked on as the president of the land of the free said resoundingly that we were not welcome. In the midst of such chaos, legal professionals, community leaders, and everyday citizens took a stand and flooded the airports to fight against racism and Islamophobia. Here to discuss IRAP v. Trump and the Muslim travel ban, I am pleased to introduce Professor Sahir Aziz and Jay Rahman. Professor Aziz recently joined the Rutgers Law School faculty as a professor of law, a chancellor of social justice, and a Middle East and legal studies scholar. Prior to working in academia, Professor Aziz was a senior policy advisor at the United States Department of Homeland Security. Her research focuses on the intersection of national security and civil rights. Jay Rahman is a civil rights attorney at the New Jersey chapter of the Council on American Islamic Relations. The Council on American Islamic Relations is a civil rights and advocacy group that works on behalf of the Muslim community of the United States of America. Prior to his career in the law, Mr. Rahman had a career in the New York State politics. Please help me in welcoming Professor Sahir Aziz and Mr. Jay Rahman. Professor Aziz will answer the first question, but we have slides, so let's see if we can get those up. Do you want me to go ahead and ask your question, and then you can start, and then as the slides go? Okay. I will ask Professor Aziz's question first, and then hopefully we will have slides in a little bit. But Professor Aziz, my first question is to you. Please describe what IRAP v. Trump is and what it is all about. Specifically, what is the travel ban and how has it progressed from the first executive order until it has reached the Supreme Court?
First, I want to thank you so much for inviting me. I want to give credit to the students, Nicole Espin, Latifa Lyles, Christina Romero, Ibna Alston, and Omar Rana, and thank Professor Sean, Professor Feathers, and Dean Chen for hosting us, and all of you for taking time out of your schedules. So I should first start by noting that IRAP v. Trump, at least, has been dismissed. Part of it has been dismissed as of today from the Supreme Court. So although it is moot, at least for this particular litigation, I don't think that the issue is moot because I suspect that the third executive order, which was issued on September 24th, 2017, is probably going to be relitigated starting at the trial level, and we'll see if it gets up to the Supreme Court. And I can offer my analysis as to whether I'm relieved or frustrated that it was dismissed because like any case that goes up before the Supreme Court, when you have civil rights and civil liberties implications, sometimes the court can do more damage than good. And this was a case where I can see it going both ways. So first, let me just tell you a little bit about the executive orders for those of you who don't know. The first one went out on was issued on January 27, 2017. And it was, not only was its content very troubling, but the process in which it was issued was very unusual and antithetical to our internal democratic process. So there was no interagency review. If you all recall, Sally Yates, who was the acting Attorney General, refused to sign off on it, or to at least litigate, to defend it when it was challenged in court. And so here's the map, but I'm just going to focus on the executive orders. And the Department of Justice had very little knowledge, and other agencies, DHS even had very little knowledge, and so it was kept in a very small circle of advisors within the White House, of whom, to the benefit of the litigants who were challenging it, of whom had a very clear record of anti-Muslim bias prior to their becoming advisors to Trump. So that was actually evidence or information that could be used to oppose the executive order. And in a nutshell, the executive order does the following. So first, it's suspended for 90 days all immigrant and non-immigrant entry into the United States. So that means legal permanent residents, people who, as well as students, people with work visas. So anyone who is not essentially a citizen of the United States, but is a national of Iraq, Iran, Libya, Sudan, Somalia, Syria, and Yemen. And I believe in total that comes out to something around 180 million people in terms of their population. It limits the refugee entries, total refugee entries, to 50,000 in 2017, in contrast to 110,000, which was what Obama had set. And there's every year the president has some discretion as to what the limit is, although there are supposed to be processes in place to set that limit. It suspended all refugees for 120 days from Iraq, Iran, Libya, Sudan, Somalia, and Yemen. And it indefinitely suspended all refugees from Syria, which is right now the worst refugee crisis in the world. And we're talking about 4 million refugees and possibly 7 million in the coming years, because the conflict is not abating in Syria, unfortunately. And then it also provided exceptions and priorities or preferences to refugees from minority religions from these countries. So most of the minority religions would be of a Christian denomination or a Christian faith, and some who may be Jewish, some who may be Baha'i, Zoroastrian, other, but clearly these are Muslim majority countries, so if you are not Muslim, you would get a preference, you would get an exception, a possibility of an exception. So the result was 60,000 to 100,000 visas were effectively revoked. So imagine, and this isn't actually a hypothetical, this is real. You had many people who were abroad for the holidays, for example, who had permanent residency, who had student visas, many of them may be Rutgers students, who could not come back in the country. They may own homes, they may be registered in school, they may have jobs, etc., family here. So, as Omar stated, there were protests across the country. I'm proud to say I was participating in the one that took place in Dallas-Fort Worth, which is where I lived at the time. And I know that there were quite a few protests here in Newark, at the Newark airport, and I'm sure in the New York area. And kudos to those of you who participated in them. And I'll talk a little bit after you ask more questions of the impact of that. The second order, so after the litigation, which as you can see here, this shows you the timeline of the litigation. So you've got litigation in Washington State, in Maryland, in Virginia, in Massachusetts, in New York. There were multiple lawsuits filed across the country seeking preliminary injunctions, right? Temporary restraining orders, and then extending them to preliminary injunctions until the executive order could be litigated on the merits. And Many of them were successful. There were a few that weren't. I think the federal court in Boston did not issue one, but most of the courts, particularly in Hawaii and in Washington and in Maryland, did. So there was quite a bit of pressure on the Trump administration to litigate. So he was doing what many executives will try to do, is moot the issue by issuing a second one on March 6, 2017. In this one, he removes Iraq, and the rumor, or I'll say the unspoken explanation or unofficial explanation, is due to foreign relationships with Iraq. The Iraqi government was very upset that they were on the list. They considered themselves an ally of the country, and as you can imagine, because we occupied the country, they are people that we have handpicked, and so they felt that they were very upset and communicated that they were on this list. He also then fixed a few things. He exempted legal permanent residents, so they were then able to, they were not subject to this ban. He exempted dual citizens traveling with a passport not from the list of banned countries. So if you were a Yemeni national and a British national, or a Yemeni national and some other nationality that isn't on the list, you could enter as long as you were using the passport from the non-Yemeni passport, using it as an example, or non-listed country. He exempted asylees and refugees already admitted into the U.S. He removed the indefinite ban on Syrian refugees, but kept the 120-day ban for refugees, or at least the suspension. He removed the priority for the minority religions, because there was a very serious Establishment Clause challenge there. And it applied only to individuals outside the U.S. who did not have a valid visa as of the time of the first executive order and have not obtained one prior to the effective date of the second order. So all of these are ways that he is trying to make it withstand constitutional scrutiny and to not violate the various claims that were brought against it, including the Immigration and Nationality Act, the Establishment Clause, Equal Protection Clause, and the Religious Restoration Act. Those were the main, and then there was an Administrative Procedure Act claim brought. And he also beefed up the explanations, the national security concerns, and brought more information, but much of it is what we're used to seeing in the national security arena, which is very vague, and kind of broadly worded, fear-driven statements. So conditions in these countries present heightened threats. It's very broad. Each country is a state sponsor of terrorism, has been significantly compromised by terrorist organizations, or contains active conflict zones. Only 3 of them have actually been designated as terrorism states by the Department of State. So they were not, in fact, to be a state sponsor of terrorism is a legal designation by the Department of State. There's a process for that as well. They were allegedly less willing or less able to provide necessary information for visa or refugee vetting processes, and then the very broad allegations that people from these countries had a heightened chance to be part of terrorist operatives or sympathizers. And it alleged that 300 persons who entered the U.S. as refugees are currently subjects of counterterrorism investigations, without stating that those subjects were nationals of those countries. So from an evidentiary perspective, or from the nexus was very loose and the language was very broad. And also a few things that went against it for purposes of litigating the second order is that the White House press secretary, Sean Spicer, stated, well, to the base of Trump, don't worry, the principles of the second executive order remain the same. Right? And Stephen Miller, who was the mastermind behind much of what we think are very Islamophobic policies and practices, described the changes as mostly minor technical differences, emphasizing that the basic policies are still going to be in effect. So all of these are important facts, because when the litigants challenged the second executive order, they were able to point to that to say, this is really just a thinly veiled, kind of more polished version of the first executive order, which was much more blatantly anti-Muslim. So I will get more into why the courts issued the preliminary injunctive order, and why the Supreme Court was willing to grant petition for writ on this case in the next line of questioning.
Thank you, Professor Aziz. Mr. Raymond, how has the travel ban affected the communities you work with? How has the travel ban affected racism and Islamophobia in our nation? And how are people that you work with affected still by the third travel ban?
Good evening. First, I'd like to thank you guys for inviting me. So just to get right into it, as your first question, how has it affected the communities that we work with? When 1.0 was released, given the rhetoric that was happening during the campaign, during the 2016 election, there was a fear amongst the Muslim community that we're being seen as outsiders, as being unwanted. There was whisperings and even questions being given about how we were going to get deported, or be put in concentration camps, or become refugees ourselves. When the order was released, we saw massive chaos at airports. Green card holders, students were denied entry, visa holders were denied entry, and as to Professor Aziz said before, there was actually a Rutgers student who was visiting her sick mother in Syria. She held a Syrian passport, and when she tried to come back the night of the ban was instituted, she was also denied entry, and so Rutgers intervened and got her to come back in. Prominent Americans, Iftihad Muhammad, a gold medalist from New Jersey, was denied entry. Muhammad Ali's son was denied entry. So these were just certain examples of okay, so this isn't just affecting international travelers, but it's actually affecting American citizens. But then came relief. The mass protests across the country from coast to coast. In Boston, Massachusetts actually organized a protest that brought out 20,000 non-Muslims. I think that's the key here. It wasn't just Muslims protesting, but we had non-Muslims out there saying that this ban is un-American, that it's against our Constitution, and that it infringes on American Muslims' rights. In New York, we had Senator Schumer do a protest outside of JFK. So all this helped quell our fear that, okay, we're not alone here. There are people out there that want to fight with us. Then came further relief by the courts. The Eastern District of New York issued a automatic stay of the ban 1.0, and then as we went along, the Fourth Circuit and Ninth Circuit also stayed the ban as it moved up to the Supreme Court. So what effect did that have? We weren't a lawless society. The Constitution still mattered. And the government was on the side, or not on the side of the government, but the courts were on our side. So the Trump administration couldn't just do whatever they wanted, that there were legal checks and balances. On top of that, I can only speak for CARE New Jersey, but we had outpouring support and donations from non-Muslims. We had lawyers calling us up and saying that we want to get involved, we want to volunteer, how to be called out. And CARE National, our national chapter that's located in DC, received grants without even applying for them. So think of the mindset in the country that was happening, right? On one side you have people saying that, oh hey, ban all Muslims. We're seeing on TV, ban all Muslims. Muslims are evil. We're terrorists. But then we had the legal community and people who have, philanthropists who are saying that no, this is not right. So pouring money into helping us fight the ban, and the national and mostly the rhetoric that was coming out of the White House. What we also saw was, and just to give a personal story, so I actually work in commercial litigation, business law, start from last year to this year, and then when the immigration ban happened, or Muslim ban happened, I decided that right then and there, I gotta get involved. I have to get involved in civil rights. This is what my calling was. So I left my old firm and joined CARE New Jersey. During my first week, I had about 6 requests for Know Your Rights presentations. And Know Your Rights presentations are what we give to different communities to let them know what their immigration rights are, what their rights as citizens are, what their rights as Muslims are. And one question that I kept getting asked, and which is funny because we're in the 21st century, is cell phones. If I'm going to the airport, if I'm coming back, can the CPB, the Customs and Border Patrol, check my phone? What rights do I have? What privacy rights do I have? Can they just take my phone? And what if I decide to not give it to them? Can I be detained? How long can I be detained for? What if I have a thumb identification, right? Password, do I have to give my password? Unfortunately, there is no law yet. The Supreme Court has not decided this issue. One issue has been decided in, I believe, in Washington, but don't quote me on that, where the court said that there is privacy rights to a cell phone and that they cannot ask your password. But we were working with, just like putting together stuff and putting together ideas that, okay, well, this is what the court has decided in previous cases. Based on that, it doesn't apply to your phone. And then we started telling people, like, take burner phones, because, if they ask you, you might have to give it, and we can't help or prevent you from that situation. So that's one thing. Then as we saw with 1.0, the challenges were mounting, so they released 2.0, which was a little bit chaotic as well, because now, guess what? Trump administration said that your grandmothers could be, our grandmothers, our little tiny, women, can be terrorists as well. And the court again got involved and created the bona fide relationship test. So again, as there was fear mounting because 2.0 came on my birthday. Thank you very much, March 16th. But the court stepped in and offered relief. So time and time again, we kept seeing that, all right, the administration is going to try to do whatever they can to promote Islamophobia, but the courts have our back. As to your second question, Omar, what effects does the ban have on Islamophobia and racism? For the first time, at least in modern history, we're seeing that religion is becoming a polarizing issue, right? If you support Muslims, you're seen as liberal, or you're seen as Democrat, and other various epithets that are being said about liberals. If you're against Muslims, then you're a Republican, you're a patriot. If anyone was following the news very closely, our Republican elected officials didn't really say anything about the ban 1.0, right? It was mostly Democrats who come out and spoke. There were Republicans who spoke, but not as a majority, whereas the majority of Democrats came out in droves and were like, no, this is wrong, this is unconstitutional, we cannot stand for this. And the other interesting thing is that the ban is being marketed as for national security interests, not security purposes. Well, now you're promoting deep division, right? You're framing refugees as being individuals who themselves are running from terror, running from ISIS, running from Al-Qaeda, and you're saying that they are terrorists. So refugees are now terrorists, those who are escaping fear, who are escaping terrorism. Then on top of that, as Professor Aziz said, from 1.0, Trump came out and said that individuals of the minority faith would be given preference. So now you're saying that, all right, so now Christians or Zoroastrians or whatever, those are being given preference, but you're not allowing Muslims to come in. So now you're already framing this, one little by little, you're framing this as like showing the person in the mind of the average person that Islam equals terrorism. Look at the media, right? Liberal media, whether it be liberal media, whether it be Fox News, well, I say that in quotes. Anytime there is an attack or any kind of act by a person who says they're Muslim, suddenly they're terrorists. But did anyone see what happened last week with the Las Vegas shooting? Was that individual ever labeled domestic terrorism? Was that word terrorism ever used? No. So, as you see these little things like microaggressions little by little, and the ban was just kind of the symptom of all this that has been building up for the past 16 years. So it creates an atmosphere of Islamophobia and deeply entrenched into the mindset of the American citizenship, of the American public. Just to give you some statistics, from 2015 to 2016, CARE as a group, we track any kind of hate crimes against Muslims. We've been tracking it for the past, well, since 9/11 really, since we were, our organization was created. From 2015 to 2016, we saw a 57% increase in anti-Muslim bias and 44% increase in anti-Muslim crimes, which I can guarantee you after the inauguration that there was a huge uptick and huge spike in those crimes. Every day in our office, I get calls about, from everyone from teachers to managers who have showed Islamophobia. And Muslim 3.0, which I'll get to with a little later, has only increased and probably will incense further hate crime. Because when 3.0 happened, we also saw an uptick in crime, in reporting of crimes and Islamophobic acts.
Thank you, Jay. I will now turn it over to Christine to introduce the next case.
Good evening. So I'll be talking about, well, they'll be talking about LA v. Mendez. So in 2010, two officers entered the home of Angel Mendez and his then pregnant girlfriend, Jennifer Garcia, without knocking and announcing and without obtaining a warrant. The officers fired 15 shots, seriously injuring both Garcia and Mendez, and resulting in Mendez having to have a part of his leg amputated. They brought suit seeking damages for their injuries, and their case made its way all the way up to the Supreme Court on Fourth Amendment and proximate cause grounds. These are the facts of LA v. Mendez, which was decided in May. To discuss this case, we have Professor Alexis Carterin, the director of Rutgers Law School's Constitutional Rights Clinic and assistant professor of law. With expertise in Fourth Amendment law, Professor Carterin is known for spending a great deal of her career suing the NYPD. As a senior attorney at the NYCLU, she played a critical role in challenging the NYPD's stop and frisk practices. And our first question for you, Alexis, is to present the facts of the legal question and the ruling.
All right, thanks, Christine, and good afternoon, everyone. Thank you for being here. So this case is one that might be a little bit surprising to have on the agenda for First Monday. I'm curious to know how many of you had heard of this case before you heard about this program today. Yeah, very few, exactly as I expected. And that's because this case had some potential to be interesting in terms of Fourth Amendment law on the use of force. It turned out to be a little less interesting than planned, but it still provides a really interesting window into Fourth Amendment doctrine when it comes to use of force, a topic that's been in the news quite a bit in recent years for important and obvious reasons. So Christina's already given us a little bit of an overview of the case, but I want to dive into the facts a little bit more because I think they're really, frankly, outrageous. So we had some LA County Sheriff's deputies who were out looking for a parolee who committed a parole violation. He was not known to be particularly violent. He hadn't just committed some crime, but basically he committed a parole violation. He didn't check in with his parole officer, and they went out to look for him. One deputy received a tip that this parolee, Mr. Odell, had been seen riding a bike in front of a house. Now, when I hear riding a bike in front of a house, that does not particularly make me think that there's any connection between this person and the house. When I ride my bike, I ride by houses sometimes, and I don't know anything about what's going on in those houses or the people in them. But for whatever reason, the fact that he had ridden his bike by this house aroused the attention of the sheriff's deputies. And so they showed up at the door, and they talked to the woman who owned the house and asked her if they could search for Mr. Odell. And she said, no. Do you have a warrant? And they said no. And she, knowing her Fourth Amendment rights, as I hope so many of us do, said, no, then you can't come in my house and you can't search for this guy, who she did not know and had no connection to her whatsoever. And they said, one deputy who appeared at her door said that he thought he heard someone running through the house while they're having this conversation with her. And so then they said, okay, if you don't let us in, then we're going to knock down the door. And so then she said, okay. And those of you who've taken criminal investigation know that's not really good consent, that's coerced consent, saying we're going to knock down your door if you don't let us in. So they search the house, and they don't find Mr. Odell, who had been riding his bike past the house. But then they decide that they are also going to search the backyard of the house, where there are a number of structures, there are some abandoned cars, there's some trash laying around. Somehow, in the course of this unfolding, the deputies get word that there was someone named Angel who lived in the back of the house with a pregnant woman. So two deputies go in the backyard, they're looking around, they see this shack back there. It has an air conditioner sticking out of it, it has a hose running out of it, there's a gym bag and some other things around that seem to indicate, as they knew, that somebody lived there. But there's a blue tarp or kind of blanket hanging over the entry to the shack. And they go to the shack, and they don't knock. They just lift up the tarp and go in. And Angel, Mr. Mendez, who's inside, hearing someone approaching, he thinks it's his landlady, basically, the woman who owned the house. And he has a BB gun, and he has kept this BB gun with him for the purpose of shooting rodents and other critters that sometimes enter his home. And the cops come in, and he has this gun. He kind of shifts the gun. He doesn't point the gun, but he kind of moves it out of his way so he can sit up in bed. And one of the deputies sees gun, yells, gun, 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 and they shoot him. And they shoot his partner, who's there as well. And as Christine mentioned, he ended up with very serious injuries, ended up having to have part of his leg amputated. His partner ended up being shot in the back. And it's really, a complete tragedy, I think, in every way that we can think of. The cops have made a mistake. They've gone in somewhere where they didn't have a warrant to enter. They didn't knock when they did. He had a BB gun and not a real gun, and he wasn't even the person they were looking for in the first place. But now we have the thorny legal thicket that unfolds when you have the use of force like this. So on one hand, I think most lawyers looking at a case like this would probably just say, well, obviously, the sheriff's deputies acted inappropriately. There's this innocent man who's been very seriously harmed, and the county should pay for his damages. But this is why you all are in law school, so you can learn that it's not that easy, and there are lots of questions to answer along the way. So I want to tell you really quickly about what the Ninth Circuit said in this case, and then what the Supreme Court said this May. So the Ninth Circuit said that the deputies had violated the warrant requirement by entering the shack without a warrant, and they agreed with the district court ruling that Mr. Mendez and Mrs. Mendez were entitled to just $1 of damages, which basically signals that, okay, fine, enter the shack without a warrant. Yes, technically that's a violation, but it's not that big a deal. We're just going to give you nominal damages of $1. They also separately analyzed the deputy's failure to knock and announce when they walked into the shack. They just barged right in instead of saying police or knocking on the door or doing anything to signal in any way that it may not be a good idea to pick up your BB gun at this time. But they got qualified immunity on that claim. And I won't bore you with the details of what qualified immunity is. Those of you who have taken perhaps the civil rights litigation class or my class or federal courts probably know, but I'll tell the rest of you that qualified immunity is a doctrine that's a defense available to government defendants, and it allows recovery only for violations of clearly established law. So the basic idea is that if there wasn't a prior case that got at kind of a similar issue, then the officer is not on the hook, is not liable to pay damages. And then separately, the Ninth Circuit upheld the district court's ruling that the shooting violated the Fourth Amendment because of something called the Provocation Rule. Now, this is a Ninth Circuit special rule. As a former clerk to the Ninth Circuit, I tend to like a lot of rules that they came up with and don't like when people talk badly about the Ninth Circuit. But this is what really attracted, I think, the Supreme Court's attention to this case. And the Provocation Rule basically says that when an officer intentionally or recklessly provokes a violent confrontation, if the provocation that led to that is an independent Fourth Amendment violation, then that officer may be held liable. So in this case, they said that the warrantless entry into the shack was its own freestanding Fourth Amendment violation, and that was enough. The fact that that warrantless entry led to the shooting was enough for them to say that the Mendezes were entitled to recover. And they did recover. They got a $4 million award in the district court, which was upheld by the Supreme Court. But then the Supreme Court got their hands on it. So the questions that the Supreme Court were considering, were whether the Ninth Circuit correctly imposed damages pursuant to its provocation rule, and also whether the Ninth Circuit correctly concluded that the police officer's warrantless entry proximately caused their injuries. I know you all have heard about proximate cause. One else you may not have yet, but if you haven't, you will soon in torts, the concept of proximate cause. So once the Supreme Court got their hands on this, one of the things that's really interesting about this case is that what people thought this case was going to do was answer the question of whether the legal standard should be looking at that moment in time, that split second when the officer used force, that split second when in this case he pulled the trigger, or whether we should be looking at the entire context of the situation, whether we should look at the entire situation and say kind of who's really at fault here, what was reasonable for them to have done. Was it okay because in that second he thought there was a BB gun, or should we look more broadly and consider whether the whole chain of events was actually reasonable? So the oral argument, I wasn't there, but I listened to it, and it was really kind of interesting because the justices broke down along lines you might expect. Chief Justice Roberts and Justice Alito seemed pretty persuaded by the view that the warrantless entry was not what caused the shootings. the shooting. They said, the purpose of warrants is not to prevent shootings. The purpose of warrants is to make sure that the police have some reason before they go in, that they've had this sign off by a judge of some kind before they violate someone's privacy. Justice Sotomayor and Justice Kagan pushed really hard on the idea, though, that a warrantless entry is something that's possible, possibly lead to violence. We've heard a lot in the news in the recent weeks about the Second Amendment and just how many Americans bear arms, especially at home. I think I heard on the news the other day that we have 300 million guns in the United States. And it's not surprising that you have violence in a situation like that when you have officers who are barging in and don't announce themselves. The warrant requirement does have something to say about this. And Justice Breyer asked this kind of bigger question about why are we breaking down the Fourth Amendment claims in this way, in these little boxes, warrantless entry, failure to knock and announce, and then the use of force on its own separately. Why don't we look at the entire context? And so what was really surprising about this case was that after all that and this kind of contentious argument, we had a unanimous opinion, except Justice Gorsuch he set out the case. So I think somewhat unsurprisingly, the provocation rule was deemed no good. Which again, like I said, if you're a Ninth Circuit partisan, you're not really surprised by. And they said that really we need to look at objective reasonableness of the use of force. And the provocation rule basically creates this other standard aside from the one that we previously announced. And they sent it back to the circuit court for further analysis of the proximate cause here and whether it was in fact the warrantless entry that was the proximate cause of the very serious injuries. But I do want to add just really quickly, I'm out of time, to say that, so it kind of turned out to be nothing burger. It didn't answer these big questions about, whether we should look at that moment in time or look at the entire context. It mainly just said the provocation rule is no good. But it's still worth talking about, I think, for a few reasons. First, we know that police issues continue to be a subject of intense interest, and it's also a really good example of how the legal system operates in these cases where most people look at the use of force, they look at some police issue, and they think that they, very rightly, can tell right and wrong, and have a really kind of deep moral sense about whether what happened was right or wrong. And sadly, this very formal approach that the legal system often takes here does not really do justice to that approach at all. At this point, recovery is very questionable, but we'll see what happens next.
Thank you. All right, and to the left of Alexis, we have Miss Carr, who many of you may know as Eric Garner's mother. Following her son's tragic death, Miss Carr has pursued the route of activism. Ms. Carr, along with 6 other members who lost their children to police brutality, make up the Mothers of the Movement. Ms. Carr will be addressing the impact of police brutality on communities of color. And our first question for you, Ms. Carr, is what issues do you feel contribute to officers' employment of excessive force and the police brutality that results?
Yes, good evening, everyone. I want to say thank you for having me. And I am so grateful to be in front of so many people who is interested in what we are all talking about today. Well, first I want to talk about the police brutality that goes on, especially in communities of color. They are treated differently than other communities. And we see that every day. Every day we hear about shootings. Maybe we don't hear about it, but if you look at social media, if you look it up, you will see how many people of color is shot, is brutalized in communities of color. And I think this is definitely wrong, because where you live shouldn't define if you live. But no one seems to care. In the police department, when something like this happens, they try to sweep it under the rug. But now that they see so many forces is coming out, we're speaking out against this. But, it just doesn't seem to be getting through to all of them. So that's why I'm out here and I'm trying to advocate against all of this brutality. But It doesn't only take me, it doesn't only take the mothers of the movement, because we are just the face. There are thousands of mothers of the movement out there, and we are all advocating to try to save the lives of our young men and women out there. And we can see that when police officers go into different communities, we are treated differently if I'm in the suburbs or if I'm in an urban area. As I say about my son, if my son would have been a white Eric Garner in the suburbs on the corner selling Lucy's, he would have never been murdered the way he was. He would have never even had a confrontation, I don't believe. I believe that it would have been maybe a ticket or the police officer asking him to get off the corner, or even if that. But we have to come together and we have to address this problem. And the way we address it, we have to make sure that America realizes that there is a problem. Because right now, they don't think that there is a problem. But there is a problem when there is, even in Charlotte, when the young man went into the church and killed 9 people who was praying, who was having Bible study. And what did they do with him? They put him on a bulletproof vest and took him to Burger King. Now, what kind of, and then when it comes to us, we could be not committing a crime, but they will say that they felt threatened and they'll start shooting us. They will shoot 10, 12, 15, 40 times they will shoot us. If you look at the record, there has been not one Caucasian man shot that many times, even if he was committing a heinous crime. There's no place, because I've looked it up. But I don't think anyone should be shot like that. And police officers, they should even be held to a higher standard than we as civilians, because they're supposed to protect, they're supposed to serve and protect us. But instead, they seem to disconnect. And sometimes that shield and that badge gives them the opportunity, they think, to go and harass us, to brutalize us, to do as they want to us, and they get away with it. There's no responsibility, there's no accountability, and soon as one of our children get killed, what do? They start a fund for that police officer who have killed our sons or our daughters. They start to criminalizing our children. They look up the criminal record, if there's a criminal record. But what about that police officer? Do you look into his record? Do you see what he has done to the citizens of America, of that state, of that city? No. They collect money to give to his family. Our families, they forget about. They don't worry about if the funeral costs are paid. They don't care about what the parents is going through, what kind of mental anguish that they're going through after the child is killed. No, it's just another news story. To them, it's just another news story. To us, it's our life. This is something that we live with for the rest of our lives. And no one seems to care. So this is why myself and others, we have to speak up. We have to step out of the box. And this is not going to happen overnight, but I feel like if we galvanize, like me and mothers in New York has been doing, we don't sit back. We go to the source. We don't make phone calls. We go and we knock on doors. We go up to Albany, where the governor sits. We bring makeshift coffins up there. And we tell them we want answers. When we want you, the executive orders that number 45 is signing is so frivolous. But the executive order that we got signed was for the special prosecutor. And what this says is when one of our children get killed senselessly, unarmed, doing nothing, it takes it out of the hands of the local DA and puts it in the hands of the Attorney General. This way it gives us a fairer playing ground. It's not law, but we're trying to make it law. It's not legislation, but it is a Band-Aid until we can get law. Because, okay, it may be too late for my son, but we got to try to save other lives. We don't want another mother or father to suffer what we have been through. And we are doing our best to try to make this happen. And if we have to go to the heads, we go to the police commissioners, because this is where it starts. The head of the police departments, if they don't take action against their police officers, they think it's a free-for-all. They can do what they want to our children because there is no consequences, no accountability. They get raises, they get promotion. We look at Donovan, who was the prosecutor in my son's case, the one who was supposed to prosecute him. Where is he now? He's in Congress. Pandaleo, the one who killed my son, who murdered him after he said he couldn't breathe 11 times. He got a $40,000 overtime, and he's supposed to be on desk duty. How does that happen? But that's why I am trying to stay focused. I'm trying to get people in the communities to come together, to police our communities. Let's find out, let's police our children. Let's find out what we need to do. Let's get some action. Let's let those children know their rights and let them exercise their rights. But sometimes when we have an encounter with the police, we don't know whether we're going to walk away from that encounter. We don't know what they're going to do, even if you comply with all the rules and all whatever they ask you to do. Because sometimes I just think when I hear of these cases, it's just a thrill kill to them. They're going to go through a little investigation, but they're going to get exonerated. This is, I think, their thought is. And even if you just, anything to them is a weapon. And they tell you, oh, I felt threatened. Just like what Alexis was saying, that these people, they did nothing wrong, and they were shot. The man lost his leg. The woman was pregnant. She could have lost her baby. But did they think about 2 lives would have been lost if they had killed her? They didn't think about that. All they did, they went in shooting. This kind of mindset has to stop. We know that there is deep-set hatred in the United States. Some kind of way we have to try to alleviate that. We talk in the communities, but we have to go out the communities. We have to make people understand that some people don't think this is real. They don't think this is happening to us. But this is real. And if you look it up, you'll see. It's a nightmare. Just like I said, my son's death is a nightmare, but it's worse than a nightmare because, see, I never wake up. But we have to do something about this, and the only way is we all do it together. Thank you.
Thank you.
Thank you, Ms. Carr. I'm going to go ahead and pass it over to Ibn.
Good afternoon, everyone. James Garcia Dimaya, a native of the Philippines, came to the United States and in 1992 became a lawful permanent resident. For 15 years, he called this country his home and lived the life of a typical citizen until he made his first mistake in 2007. Now, Mr. Dimaya is subject to the Supreme Court's decision on a vague immigration statute. These are some of the facts of Sessions v. Dimaya, a Supreme Court case with a pending decision. To talk about this matter, we have Rosa Karn Cruz, an immigration attorney with the Bronx Defenders, a holistic legal service provider for those in the criminal justice system. Rosa has been a warrior for those facing removal in the state of New York. She previously managed the New York Immigrant Family Unity Project, program to expand representation to non-citizens facing removal. We also have Sarah Cullinan of Make the Road, New Jersey, joining us in the discussion today. Make the Road, New Jersey is an organization that builds the power of immigrant and working class communities through community organizing, legal and support services, transformative education, and policy innovation. Prior to working for Make the Road, New Jersey, she worked for Make the Road, New York as a healthcare advocate. Ms. Cullinan has focused her career on advocating for immigrants in need by helping them organize and fighting for their healthcare rights. Ms. Cullinan will be addressing the impact of the constant threat of deportation has on immigrant communities. Now please help me in welcoming Ms. Rosa Cullen Cruz and Ms. Sarah Cullinan.
Hi everybody, thank you for having me today. I do want to talk about the law, obviously, but I also want to just give a little bit of perspective. My job at the Bronx Defenders is to work with people as they navigate the criminal justice system and often consider how to resolve their case, whether it's better to risk a conviction at trial or take a plea and consider the immigration consequences in both avenues. And so a vague immigration statute, a vague ground of removal can be really difficult for my clients in having to make that decision. So I start with that to say that that's the perspective that we come from and why these types of statutes are so incredibly problematic for people as they navigate the criminal justice system. So anyway, I do want to back up. This case was well introduced. I'll go a little bit more into the facts, but what we're really talking about here for Dimaya, he's a lawful permanent resident, which means that he can only be removed from the United States if he violates certain immigration laws. And Dimaya had 2 convictions for burglary in California, and they were charged both as crimes involving moral turpitude and as crimes of violence, aggravated felonies. And it's important to note this because had they just gone forward, the U.S. government just gone forward on the CIMT, crime involving moral turpitude ground, he still would have been removable. So this is not a question about whether or not Mr. Dimaya would have been removable. It's really about relief eligibility. This is a person who had been in the United States for a really long time, and certain lawful permanent residents, they've been here for 7 years continuously and at least 5 years as lawful permanent resident. They're eligible for what's called cancellation of removal, which is when you get a chance to go in front of the immigration judge and kind of have a conversation about your life and talk about the reasons why you're deserving of staying. But an aggravated felony just cuts that conversation off. You never get to talk to a judge about why you should be allowed to stay in this country. And so a lot of people think, oh, you're put in removal proceedings, everybody has the opportunity to fight their case, and that's just not true. You have to be eligible to even tell your story about why you are deserving of staying, to borrow. It's a balancing test. So he wasn't allowed because the immigration judge sustained the ground of removability that he had a crime of violence, aggravated felony. He wasn't given the opportunity to even ask to be given a second chance to stay in this country, despite, all of the good, what we call equities that he could have brought forward. He wasn't even permitted to have that conversation. So that's what this case is kind of about, is, this ground, this aggravated felony ground, crime of violence. And a second point is that there's actually 2 definitions of crime of violence. One of them, it's 18 U.S.C. 16, is where you find the definition for a crime of violence, and one of them is an offense that has the element of the use, attempted use, or threatened use of physical force against the person or property of another. That's 16A. And that's not the one that we're talking about here, and that one is slightly more clear. 16B, the one that Dimaya was charged with, is also called the residual clause, and it's any other offense that is a felony and that by its nature involves a substantial risk that physical force against the person or property of another may be used in the course of committing the offense. So that, to me, right on its face, sounds really vague. What is a substantial risk that physical force will be used. And I'll get into a little bit more of this later, or potentially in a few minutes if I have time, but one of the major issues with the residual clause is that you see courts having trouble figuring out how to apply it. And you have these really kind of arbitrary and wildly different determinations about what is a crime of violence, aggravated felony, under the residual clause. Another important point here when we're talking about immigration and criminal statutes is that most of the time we're talking about state criminal statutes. And so you're taking a federal definition and then you're applying it to very varying statutes. And in immigration law, when deciding if something is an aggravated felony, we employ what's called the categorical approach. So we're not looking at what did this person actually do, but we're looking at what is the statute he was convicted of. And that's another reason why you can have these wildly different results, because what we're really talking about is the statute, not the individual act that the person may have committed. So that's a lot of context. I hope I didn't use up all my time in context, but that sort of sets the stage for where we are. One other really important piece of background is that there was another case in 2015, Johnson, which dealt with the Armed Career Criminal Act, which has a similar clause, a similar vague clause. And Johnson was struck down as being vague. In Johnson, they found it unconstitutional because it didn't provide guidance on how to determine whether an ordinary case of any given offense involved the risk of harm that the residual clause in Johnson contemplated. And similarly here, there's no guidance in the text of 16b of the residual clause for the crime of violence as to whether or not the ordinary case involves a substantial risk that physical force will be used against the person or property of another in the course of committing the statute. So as the ACCA residual clause was struck down in Johnson, similarly, the Ninth Circuit has held that the residual clause in the crime of violence context, 16b, should also be struck down. And the Ninth Circuit, what happened in the case, the procedural history, is that he was found removable in front of the immigration judge, the Board of Immigration Appeals affirmed, and then the Ninth Circuit held it in abeyance pending the Johnson decision of the Supreme Court, and when it was struck down as vague, void for vagueness, the Ninth Circuit reversed and also found 16b void for vagueness. So a lot of us sort of felt like, well, this is great. This is like the end of the story. In fact, in Johnson, the government themselves said, well, if you're going to find the ACCA residual clause void for vagueness, then that's also going to mean 16b is void for vagueness. And they're stuck having said that. Of course, now they're starting to backpedal a little bit, and they've tried to come up with some arguments as to why 16b is different from Johnson, from the violent crime category in Johnson. So one thing that they're saying is that the 16b residual clause involves force instead of injury, which is what was at issue in Johnson. But that seems to me kind of like a ridiculous argument. If what we're talking about is vagueness, injury seems much more specific and sort of measurable than the risk of use of force. So that's just, oh my gosh, I only have 2 minutes left. That's just one interesting thing. Second is they said that there was a temporal limitation, that the use of force had to be involved in the commission of the offense. So it sort of was in a closed universe of time. And then there was they also tried to say, and what's most important is that Johnson was a criminal statute. We were talking in Johnson about a criminal statute, whereas here the penalty is civil. And that when a penalty is civil, there's not the vagueness doctrine isn't as important, it doesn't apply. And there is some precedent for that. However, we're seeing more and more the Supreme Court is taking seriously the civil, especially immigration consequences of criminal convictions. And they're not, in Padilla v. Kentucky, which is basically where my job comes out of, but mandates competent immigration advice in taking a plea to a criminal conviction, the Supreme Court stated that an immigration consequence is more than a collateral consequence. It is a devastating consequence. We're talking about permanent banishment. We're talking about being torn from families, being kicked out of this country, and especially in the aggravated felony context,